Welcome to the law library. Kind of quiet in here, isn't it? You know, some people are afraid to come to a law library. It's not hard to understand why. How are you going to find what you need? Books in here look pretty much the same, don't they? Pretty confusing. Volumes like these contain 6 million cases. How are you ever going to find the one case that you need? How do you know where to start? You can get lost in here. What if you missed something? Feels like a maze, doesn't it? Or maybe a foreign country. There's just too much stuff. But don't worry, there is an answer. Legal research doesn't have to be an insane enterprise. It can be done in a systematic and straightforward way. I'm Bob Baring, Director of the Law Library and Professor of Law here at the University of California at Berkeley's Boalt Hall School of Law. And the purpose of this tape is to teach you how to do legal research, to make sense of all this craziness. But I don't want to talk about legal research in the midst of all these books. That's too overwhelming and confusing. Let me take a few important volumes and let's go to a place that's a little more comfortable to start thinking about these problems. There. This is much better. Legal research doesn't have to be chaotic. We can approach it in a common sense way. Now, one of the best ways to do that is to come to a comfortable setting like this. A roaring fire, a pleasant room. We've even brought the books from the library with us. And let's take a view of legal research that steps back for a second. Why did you buy this tape? You bought this tape, I assume, because you want to understand how to use legal materials. You don't want to be intimidated by going into a law library. There's no way that I can teach you the substantive law. That's not what this tape is about. What this tape is about is teaching you the mechanics, the skeleton of the legal structure of American legal research that you can take with you into any research situation. I want to demystify the library. I don't want you to be worried when you go into the library stacks. I want you to be able to pick up any book in the collection and understand what this book is trying to do. That's the functional style of research training that I've developed over the last 15 years, and that's what we'll try to talk about in this tape. Now, I'm also going to try to give you a research plan, a concept that I call a research roadmap, a way to think about your research, to plan your research, to think ahead and understand where you're trying to go and how you're going to get there. There are 4 challenges that are going to stand in your way of doing effective and efficient research. What are they? And the first of those is the fact that we in the United States live in a common law system. Now, what's a common law system? A common law system is a heritage that we borrow from the British. It means that our courts of law can write decisions which have an impact on the rest of the legal system. And in fact, during the course of this tape, you're going to see that much of our finding tool apparatus is arranged around these cases. Now, because the cases are not a natural part of other research, not a part of the average person's daily experience, they will cause some problems. But I'm going to show you some ways around that. We'll show you how to make the cases understandable. We'll show you how to put them into the right perspective. And even more important, we'll show you that there are some pre-existing patterns of case publications that can make it possible for you to see clearly what each case contains. We'll see that some publishers in the legal field have already organized information systems that you can exploit to move from one source to another. So it's a problem, but it's a problem that we'll recognize and try to deal with. The second challenge to effective legal research is the fact we live in a federal system. The United States is a federal union of 50 separate states. Each of these states is called a jurisdiction, and each of these jurisdictions has the right under our Constitution to have its own legal system. That means it has its own set of courts. It has its own legislature. It has its own administrative agencies, and it publishes its own stuff. Each individual state can name its materials and organize its materials however it wants. Now, that's going to cause some special problems for you as a researcher. You can't possibly memorize it all. I've been working at this stuff for 15 years, and I can't memorize it all. You'd have to be the Dustin Hoffman character in the movie Rain Man, some sort of idiot savant of legal research to know all of this stuff by heart. And I think that's what scares a lot of people. I know when I was a law student, they would roll in trucks of books, call off the names of sets and say, this contains this and that contains that, and these contain those. I was totally lost. The way around this is going to be to look for patterns. Patterns in the way the material is published. Patterns in the way we organize our information. It's these kind of patterns which are going to help you in your research. And we'll look to those patterns. We don't have to memorize the names of all the sets if we understand how the sets are put together. Now, what's the third challenge to legal research? The third challenge to effective legal research is legal jargon. The lawyers and judges in the United States have developed their own special vocabulary, their own special way of talking to each other. Now, this is true of every profession. It's not just the law. Medicine, social sciences, the natural sciences, everybody has their own internal jargon. The problem in the law is that legal jargon is used to organize information, that we build our indexes and our subject arrangements around this jargon. So that's going to cause a special problem. And it's one of the things that intimidates people when they go into a law library. We will look, as we go through this tape, for ways to avoid the jargon problem. We'll look for ways to find natural language indexes. We'll look for ways to find someone who's arranged material for us. In every one of these areas, we'll try to highlight the jargon difficulties. Now, what's the fourth challenge to effective legal research? The fourth challenge is simply there's too much stuff. In my library at the University of California at Berkeley, we have 600,000 separate volumes. We also have tens of thousands of pieces of microfiche and probably millions of documents accessible through electronic databases. That is just too much information for any individual to cope with. And it means that as a researcher, you're going to have to be extremely careful to have a research plan, to come at your information in an organized fashion, to try to plan your research and have a concept. And for that reason, I'm going to give you what we call a research roadmap, a way to think about and conceptualize your problems, a way to put information together. Now, those four challenges all have to be looked at in light of the vast array of legal information. So I'm going to give you a model now to think about legal information, a way to think about every book that's in that library. What I want to do is demystify that material for you. I want to make it so you could walk into any law library in the United States, pull any book off the shelf, and understand what that book is. Now, the first key to that is to understanding what I call the research spectrum. I divide all legal information out on a spectrum, beginning on the left side with primary source materials, all the way out through a variety of secondary sources. And I want to walk through this diagram with you to explain the types of materials. Then we'll go back and look at how they're organized and how you work with them. On the left side of the spectrum, we have primary source materials. Now, what are primary source materials? Primary source materials are statements of the law itself. Now, some people call this black letter law, or you might see it referred to as positive law. The point is, it is not a description of the law, it's not a discussion of the law, it's the law itself. One of the most famous legal educators in American history, Christopher Columbus Langdell, the dean of the Harvard Law School who founded modern legal education, used to call legal research materials, and primary sources especially, the stuff of legal research. Just like a chemist, Langdell would say, we work in a laboratory with the primary sources. In a way, that's not a bad analogy. The primary sources are the statements of the law that drive the whole engine. Now, you can see we have 4 levels of primary source material, and I've arrayed them in the order of impact. That is, they're hierarchical, some more important than others. At the first level, we see constitutions. Constitutions are the rules by which the game is played. At the federal level, our U.S. Constitution describes how the entire system works. In a way, it's like the rule book in baseball. It tells you what you're allowed to do, how to do it, how to implement, what you are allowed to create, and how to create it. There are substantive parts, but there are also purely mechanical parts. And it is the bottom line. If something does not meet the standards of the Constitution, it fails. The second level on our diagram is legislation. Now, legislation is the statutes that are passed at the federal level by our Congress. Bills that reach the approval of both houses and are signed by the president, or in which the houses of Congress override his veto. It's the legislative enactment of our representatives. And some people think this is what the law is and nothing else. It certainly is an important step. One that I think is, in fact, far more important than, for example, cases. But it's only another level, and it is subject in our hierarchy to the Constitution. We've established in the United States that if a law does not meet the standards of the Constitution, the courts can declare it unconstitutional and the law fails. The third step is administrative rules and regulations. Now, administrative rules and regulations come from administrative agencies. Now, at the federal level, these are the giant agencies that we're constantly reading about in the newspaper: the Federal Aviation Administration, the Home Loan Bank Board. All of these are administrative agencies which were set up by the federal legislature, by the Congress. Why did they set them up? They set them up because as life has progressed and society has gotten more complicated, the legislature simply can't deal with everything. There are some matters that are simply too complicated. Take the Federal Aviation Administration. Congress, as a legislative body composed of our elected representatives, knows that it cares about airline safety. But at least they're smart enough to know they don't know how. So they hire experts, and they create an agency and say to the Federal Aviation Administration, you regulate these problems. You have the expertise. And also, you can have the staff to handle the minutiae of regulations that the legislature could just never get to. Now, that means the rules and regulations coming out of these agencies are always subject to the power of legislation. The agencies are set up by legislation. They're regulated by the legislature. And of course, they all have to be constitutional. But this third level, I think, is one of the most important. All you have to do is open your wallet and you'll see plenty of indicia of administrative rules and regulations in your own life. I love a Russell Baker column from a few years back where he talked about the importance of administrative law and how it's invaded all of our lives. And what he said was, I woke up this morning, my clock radio went on. My clock radio, of course, is fire safe. That's certified by an administrative agency. And I was awakened by the voice of a disc jockey who came to me over a federally licensed broadcasting system. And then I turned to my spouse, who's administratively licensed by the state to cohabit with me. And he went on through his whole morning, each step in the morning being covered by administrative law. So that's going to be very important. Now, what's our fourth source of primary law? That's the tricky one, case law. Because again, in our common law system, the decisions of the courts are a primary source of law. If I sue you and our matter goes to court, of course the matter is settled between you and me. That's what the courts are for. But the decision of the matter between you and me might make a legal precedent. That's something that could be referred back to by people in the future. If you sell me a car and I take the car home and the car doesn't work, and I sue you, I say I want my money back. If the courts decide that I get my money back, of course I do get my money back, but we might have established a principle that exists between people who sell things and people who buy things that folks in the future could refer back to. Now that's called precedent. The courts can also review administrative rules and regulations, the third level, and explain what those mean or interpret them. They can also look at legislation, the second level, and explain what legislation really means. And of course, it can always test everything in light of the Constitution, the top level of our primary sources. Now, that's one of the things that makes the whole process so difficult. It all interrelates. Legislation has to be constitutional, and it might authorize administrative rules and regulations. And the courts might comment on all three. You have to understand these primary sources. But one of the things we're going to see in these tapes is that oftentimes you don't have to work with them. There are going to be lots of ways to get information that help you organize and sort these primary sources. But it's always going to be crucial to remember, am I dealing with the law itself or something else? And the something else is what we find in the rest of the research spectrum. We see things like indexes and digests. These are materials that comment and organize and describe in a very basic way the primary source materials. And sometimes it's almost impossible to see the hand that stands between you and the primary sources. The average individual doesn't think of an index as being something that actually has an impact on the material indexed, but it's true. The way that materials are indexed and arranged are what allow you access to the legislation, to the Constitution, to cases. So we always have to beware and understand that even in the act of creating an index, we have a secondary source material. As you move further on out, we'll see citators, and we'll talk about those. These are materials that let you draw connections between primary sources and between primary and secondary sources. But again, it's not primary source material itself, it's someone drawing the connections for you, usually a commercial legal publisher. Further out on the spectrum, we see narratives and descriptions. Now it's straightforward and clear. We have someone saying, I'm going to explain the law to you. I'm going to tell you what the primary sources mean, how to fit them together, how to understand them. There's a broad range of materials here, all the way from books prepared for law students to help them learn the law, to books prepared for the layperson. Many of the how-to books produced by a press like Nolo Press are designed to fill this function, to say to you, I've got a problem, I'm going to be audited by on my tax returns, here's what to do. And a how-to book will tell you, here's what the primary sources say, here's how to understand them, here's what you use. And in fact, it may be that that is precisely the answer to your research problem. As long as you understand it is an individual who is explaining it to you and that it is a secondary source. Further on out the spectrum, we have the far end, and that is persuasive authority. And here we have someone, usually a judge, a lawyer, a legal scholar, saying, there is no law in this area, but I think I know what the law should be. Or you have someone saying, there is law in this area, but it's confused or chaotic or simply incorrect, and my opinion is better. Now, sometimes you need this material. If there is no law, it's worthwhile to find out what experts think the law ought to be or will be or should be. If there is law in the area, and when you look at it, it's the opposite of what you need, that's what a legal researcher does. The researcher says, is there anyone who said something to the contrary? Is there any place where I can find support for my position? And that's where you end up with persuasive authority. Now that is the research spectrum, and that explains the full array of materials in a law library. The great bulk of the collection is going to be built around the primary sources. And 50 years ago, most law libraries were nothing but primary source materials. And in fact, 50 years ago, most law libraries were very little more than collections of the fourth source, that is, cases. In the last 50 years, legislation has grown much more important, the Constitution has come to the fore, and administrative rules and regulations have blossomed. But still, when you go into the library stacks, one of the things that may befuddle you, that may look odd, are these huge collections of primary source materials. So we will work through those in some detail at the end of the tape. Now that we've seen the full range of sources, I want to equip you with our research roadmap. I want to give you a way of thinking about this enormous amount of information. I want to allow you to sort it out into a logical sequence. And what I've done is create a 6-step roadmap to research. These are 6 levels of questions that you should ask yourself before you begin your research enterprise. Remember, good legal research in many ways is nothing more than good common sense. And therefore, I took the roadmap analogy. Let's take a trip together. Let's go do some research. Now, what's the first step in your research roadmap? The first step is, where do I want to go? I mean, if you're going to take a trip, you need to know your destination. Now, you might be saying, Bob, that's stupid. Of course I know my destination, but I can tell you from experience that the most seasoned legal researcher often makes this mistake. You're so excited about your problem. You're so full of what you want to do that you want to race into the library and do some research. You've got to step back first and say, what is it I want to find? Pretend that I'm standing there right next to you, and you can turn to me and say, Bob, what is the perfect answer to my question, and we can talk it through. Do you have some simple operation you want to perform? I'm going to be audited by the IRS. I want to know what to do. I want to change my name. Or do you have some more complex question? I feel I'm being discriminated against in the workplace. What's the law in this area? Only when you know the kind of answer that you'd like to reach in the end can you embark on your journey. This is where we get the right roadmap out. Because only if you know where you'd like to end up can you effectively start. So before you start, know your direction. What's the second step? The second step in the research roadmap is know the lay of the land. Know the basic landmarks in your area. Now, if you've done a lot of work in a particular area, you're already familiar with it, a lot of this is going to be living in your head. You'll already have internalized all of this. But if you don't know the area, you have to familiarize yourself. You know, one of the reasons I like the roadmap analogy is I remember so many trips as a kid with my father, a man who would not look at a roadmap. We would drive, and we would say, "Where are we? Where are we going?" And he would always say, "I'll find it. I'll find it." And I always used to think, if he would only look at the map. Well, I say the same thing to you. At stage 2, know the lay of the land. If your question concerns landlord and tenant rights, you should know about the basic area of landlord and tenant law. You should know what the important jargon is. And here we're back to the jargon again. You should know, are there certain books that everybody who works in this area refers to? Are there certain crucial cases? Is there one statute that governs here? You should ask yourself, is this a federal question? Or is it a question that relates to my particular state? Or is this a city matter? Will it be covered by a city ordinance in my area? This is the kind of lay of the land that you have to get before you can effectively proceed. Getting the lay of the land lies out there in the secondary part of the research spectrum. And that's why we're going to start with the secondary materials as we work our way through. In fact, probably the best tip here is to use one of my golden rules of research, and that is use a human being to get the lay of the land. Here's where you can effectively use a reference librarian in a law library. Now, the reference librarian won't be able to do your work for you, but if you go to him or her and say, "I have a landlord-tenant problem. What's the best book to look at in Texas?" Or if you're in Illinois, or whatever your jurisdiction is, ask the reference librarian, and he or she can help you. They can point you the right direction, saving you a great deal of time. So know the lay of the land. Please look at the roadmap. What's the third step in our research roadmap? That's planning your focused journey. Now that you know the landmarks, now that you know what's important, you can get down to actually designing your research plan, actually laying out the steps that you foresee in your research process. Now, this means you know the lay of the land, you know where you want to go, and now you make up your list. These are the tools that I'm going to use. I will first go to these source materials and then back them up checking here. I'm going to approach the problem from this particular way. And I would suggest actually listing this out on a pad before you start. Remember, you're going to be in there mixing it up with hundreds of thousands of volumes. You're going to need some help. Now, of course, if you plan your research beforehand, you're going to have to change that plan. It almost never goes the way you think it's going to go. But if you don't have a plan in mind, if you haven't got your route drawn on the map, you'll be lost. It's much simpler to have your route planned and have to make a detour than to simply be faced with a huge mass of legal information and not know where you're going. What is step 4 on our research roadmap? Step 4 is what I like to call, in tribute to Arsenio Hall, let's get busy. Let's do it. Let's read what we need to read. Let's go from source material. Let's find the individual items. I wish I could give you a library tour of your law library, the library that you use. But just like snowflakes, every law library is different. I can tell you about the material that's in the collection. I can tell you what you might suspect you'll want to use. I can help you plan out your research list. But what you're going to have to do is be sure that you understand your own library. Now, that might mean talking to a reference librarian in the collection. You'll find that a legal reference librarian is your best research friend. But remember, that reference librarian is a professional. You should go to that individual already having your trip planned, knowing your destination. Nothing is as frustrating for a research professional as having a question from someone who doesn't even know what they need. So when you go to that step of getting busy and actually doing your research, be sure that you have a plan in mind. What is step 5? Step 5 is, once you get to the destination, what do? Well, here's where legal research gets a little more tricky than the average trip, because they keep moving the buildings. They keep tearing things down and changing addresses, so that when you get to the end of your research journey, you might find the building gone. We constantly have to update. When you get that piece of information that's exactly what you want, when your research is really cooking, that's when you have to check. Is it still valid? Has it been changed? Has something new happened? And as we work our way through the various kinds of materials, we'll ask at each step, how do you update this stuff? How do I make sure that this is what I need, that it's valid, that it's useful, that it's speaking to my research needs? There's a second half of step 5, and that's evaluate. Because once you get to the end of your journey, you'll have educated yourself. You may have learned that, in fact, you were after the wrong answer. You may have learned that I don't really need a statute here, I need a form. Or perhaps I do have to read a case here. Or perhaps what I really need is a how-to book, which will explain step by step how to accomplish my particular goal. Evaluation. Check out where your trip has landed you. It may mean that you have to start all over, or go back to step 2 and learn another lay of the land. Here's where you have to use your own critical facilities. A lot of legal research is just plain common sense. Once we demystify the tools, take away your fear of novel jargon, shelves full of books, what you're going to find is common sense practice leads to good research results. What's step 6 on our research roadmap? Step 6 is knowing when to stop. I don't think anything is more frustrating to me than seeing individuals in the law library working away, spinning their wheels, redoing the same thing over and over again in an attempt to look at everything. Trust me, I've been at this for 15 years. You can't possibly look at everything. There's going to be no way that you'll be able to examine every available source material. What you have to do is intelligently use your plan and know when you've got to the end. Sometimes there will be no answer, and sometimes the only answer is that you have to get some help. So it's important to be able to make that stop decision. I've put in enough work. I've gotten to the end of my process. Now it's time to go out of the library, look at my results, or, as I said, get some help. Now, we've got a research roadmap. We have the research spectrum. What I would like to do at this point is go back and start looking at the materials that might be available to you. Look at them in light of the research roadmap. We'll go back through each of the 6 steps and begin with the secondary source materials and try to organize around them. See how to go about doing legal research. Question 1 in the research roadmap was, what answer do I need? Now, it could be that the answer that you need is simply how to perform a simple operation. That means how to do something. And in every jurisdiction, you will find books that explain how to do things. Nolo Press, the publisher of this videotape, is one of the largest enterprises working in this field. There's a whole series of Nolo Press books describing how to perform specific things, how to protect yourself in specific situations. Other jurisdictions will have similar books, varying from jurisdiction to jurisdiction. Within every state, the Bar Association will have some continuing legal education arm, which may put out books of forms or guides. The trick here is to be sure that you're using the right material, to talk to someone in the area. I'm back to the reference desk in the law library. Check there, or talk to an experienced researcher and say, in your jurisdiction, in your particular state, what's the most useful material for your particular problem? Here's where defining the answer that you need is most important. And it may be that once you've defined the answer that you need, and you get the lay of the land by talking to individuals, by consulting the card catalog in your library, by asking a reference librarian, that may be where you can stop. Although, of course, you'll still have to update. You always have to drop down to level 5 and update and evaluate. Do I have the most recent edition of the book? Does the book give me tips on how to update the material itself? Remember, you're far out on the spectrum. You're dealing with a secondary source. It may be crucial that you recognize it's almost as if you're using an attorney. You are trusting someone to arrange the material for you. So be sure that you're using a reputable source, one that's recognized, and certainly one that's up to date. But let's say that you want to penetrate a little further into your problem. You don't need a simple operation performed where a how-to manual is something that you're willing to trust. Or perhaps there's no book that specifically speaks to your problem. At that point, what you're going to need is a little more background. You're going to need a secondary source that helps you get that lay of the land. Now, how can you go about doing that? Well, there are a wide variety of tools available. And what I want to talk about is some types of tools. To do this intelligently, I think we have to take an example. So let's take what we call a hypothetical example. Make up some facts and see how they would apply in a research situation. Let's say that as a researcher, you're concerned with the issue of sexual harassment in the workplace. You feel that you are being harassed by a supervisor, and you want to find out what the law is in this area. Where can you find materials that will discuss discrimination in employment because of sexual harassment, or the problems that result from sexual harassment? Now, on the secondary source part of the spectrum, there are a number of ways to approach this. The first that I might suggest is called the Hornbook. Hornbook refers to a type of material published to assist law students in understanding areas of the law. Now, this really came about because of the way legal education is carried out in this country. So the same individual I already talked about, Christopher Columbus Langdell, started what we call the case method of instruction. And in that method of instruction, the students are constantly asked questions by the teacher. And in fact, part of the pedagogical method is to keep the students confused. I know that sounds crazy, but trust me on this one, it's the truth. A whole industry has arisen to try to help the students break through the confusion by simply explaining what the law is. The highest level of production of books in this area is called the Hornbook series. I have here a Hornbook on employment discrimination law, written by Mr. Player. Now, employment discrimination law would be treated in this book. This would be a descriptive tool. It would talk about what the law is. It would discuss relevant cases. It would tell you about important statutes in your area. This is a way to get the lay of the land. It has a subject index. It has a detailed table of contents. And if you had the name of a particular case, if someone said, you know, there's a very good case in this area, Bob, the such and such case. Well, before reading that case, if I didn't already know the lay of the land, I would go to a Hornbook. There will be a table of cases in here which would tell you what pages in this book will discuss the area covered in your case, so that here you'll get a little intelligent instruction. Now, the problem with Hornbooks is they are written for law students, so sometimes they are written at a level that is difficult for the lay person to understand. Some of them are quite good in this area, but some are difficult. It's worth checking upon because there's an enormous amount of information in here. But what if either there is no Hornbook or it's just too technical, too difficult to understand? Well, there's a second level of source material, and that material is called the Nutshells. The Nutshell series is produced by the West Publishing Company. There are several publishers that do Hornbook series. I showed you an example from West, but there are Hornbooks published by Foundation Press, by the Bobbs-Merrill Company, by a series of competing publishers. The Nutshell series is owned by the West Publishing Company of St. Paul, Minnesota, a player that we'll run into over and over again in the legal research business. They dominate the printed aspect of legal publishing like General Motors used to dominate automobile manufacturing. Now, what are the Nutshells? These are simpler guides. You can see how useful this one is. It's had the bananas beaten out of it by overuse. What this talks about, and you'll notice it's even by the same individual. Mac Player wrote this book as well, but this comes at the subject from a much simpler level. It doesn't go into the technical detail of the Hornbooks. Now, it does talk about important cases and would even have a case table, so that if you had a very famous case on employment discrimination, someone gives you the name of a case, you want a little background information, you want to get at it, you can go to a Hornbook. Now, law students are often warned about Hornbooks because they're too simple and straightforward. Well, that's the very reason they're useful. Remember, in law school, they're trying to keep you confused. In real-life research, you want some answers. As long as you remember that this is a secondary source, as long as you remember that you are out there on the far end of the research spectrum, that someone is explaining, as a lawyer would explain, the primary sources to you, these books can be used very well to get the lay of the land, and sometimes at level 3 in your focusing of the research as well. So the Nutshells are a simpler explanatory mode. Are there any other ways to get at this information? Well, yes, there are. There are encyclopedias. Legal encyclopedias exist at both the national and state level. There are two major national legal encyclopedias. The most famous is probably Corpus Juris Secundum, CJS. Now, Corpus Juris Secundum is probably the most famous set of law books in the world. Why? Because this is the set that sits behind Perry Mason's desk. Okay? I have this belief down deep in my heart that every moment of every day, somewhere in the world, Perry Mason is on TV. And for lawyers who are experienced in the field, it's terrific when Della Street walks in and says, Perry, we have a very complicated problem. He always pulls around and just whips off a CJS volume. But in fact, corpus juris secundum has been around since the 1930s. It works just like any other encyclopedia, except it's completely about the law. It attempts to arrange in an alphabetical order all of the possible topics that you might ever want to know about the law. The thing about Corpus Juris Secundum is it's published by the West Publishing Company of St. Paul, Minnesota. By the time we get to the end of this tape, I hope you'll be able to say West Publishing right along with me. You're going to hear it so many times. West Publishing Company, when it deals with most of its sources, has a philosophy. And that philosophy is going to become apparent in Corpus Juris Secundum. That philosophy is total comprehensive coverage. I sometimes think of legal research as a paranoid compulsives enterprise. You want all the information you can possibly get. That's the way lawyers and judges operate. And Corpus Juris Secundum is built around that concept. It's set up like any other encyclopedia, an alphabetical arrangement of topics. They've tried to think of every topic in the law that might be of interest to you, and they have an alphabetical listing for it. Now that includes definitions of some terms, but usually an article. But what do they give you with the article? They give you citations to every primary source that they think might be relevant. And in their case, that is mostly cases, the fourth of our primary source materials, because this set was started in the 1930s. And remember I told you, 50 or 60 years ago, law libraries were almost entirely volumes of case reports. This set still lives in that world. There is a fine general index at the end with good natural language indexing. It's one of the reasons I like it. Their index helps you avoid the legal jargon problem. That natural language index will refer you into the set itself. The set is arranged by volume numbers, and on the spines you'll see the name of the individual topics. Once you're in here, however, what do you find? You'll find some discussion of a problem like our problem of sexual harassment, but mostly you'll find citations to cases. The discussion, the lay of the land material, is actually very brief and often difficult to read. The idea here is that Corpus Juris Secundum was set up to refer you to cases. Now it will refer you into the West Publishing Company's research system. And we'll see as we work through the spectrum that the research system that West has developed is a very powerful one that might be of enormous assistance to you in doing your research. However, at this point, if you're just looking for the lay of the land, it might only be confusing. Before I leave Corpus Juris Secundum, let me point out something else. I mentioned earlier that legal publishers have struggled for years with the problem, how do we update our books? How do we keep them current? By far, the most popular form of updating is called pocket parts. They publish the volume once. Then they can keep it up to date on an annual basis by sending you these paper supplements. They slip into the back of the book. That way, every year the book can be brought up to date. If you read a section in here that discusses the problem of sexual harassment, you can then go to the back, look under the same topic and paragraph number, and see any new discussion and any new cases. Corpus Juris Secundum has its advantages and has a good natural language index, but it has the problem of abbreviated discussion. And it also tries to do too much. It's a national legal encyclopedia. Now, in our 4 challenges to research, we saw that number 2 was we live in a federal system. Every one of the 50 states will have its own variations of some of these legal questions, so that there's no way a national encyclopedia can really address the individual problems of each state. However, it might give you the lay of the land in the general area. It might drop you into a publisher's system. Is Corpus Juris Secundum your only national legal encyclopedia? Well, once again, the answer is no. You have an alternative. Lawyers Co-op, Bancroft Whitney's AmJur Second. AmJur Second tries to do many of the same things that Corpus Juris Secundum does. It is the encyclopedia published by the Lawyers Co-op Bancroft Whitney Company. I love Lawyers Co-op Bancroft Whitney. It's the second. It's the Avis. They have to try harder. They've been around for a long time and producing their own set of tools. And in fact, they've developed their own research system. Now that system is called the Total Client Service Library. And it stands with the West system as the second major research cross-referencing system. This is the first place we meet it, but we'll trace it through all of the tools that we're looking at as well. I think one of the reasons I like Lawyers Co-op so much is the fact that it's called Lawyers Cooperative. It's not run by lawyers, and it's not a cooperative. So there's something I like about it from the very start. Amjur Second has a separate philosophy. Lawyers Co-op, Bancroft Whitney, has a different philosophy. They are not comprehensive publishers in the way that West is. Their tradition is in believing that the researcher wants more help. West feels you want to see everything. Lawyers Co-op seems to feel you want someone to help you look at things. And therefore, Amjur Second, which started it in this edition in the 1970s, organizes itself with much more discussion and much fewer citations to authority. They will send you, in other words, to fewer cases, but they will try to pick the important cases. Amjur Second has a general index at the end of the set. It's also done in natural language style. Now, some people find the Corpus Juris Secundum indexing easier to use. Others find Amjur Second's indexing easier to use. The two companies do it a different way, so you can try both. If you did find a citation, you would find it in the same form, an alphabetical arrangement of subject topics with volume numbers on the side of the spines as well. You could then go into the discussion, and you would find, once again, general discussion of your question with some footnotes. The discussion here will be a little bit more in the way of guidance, and the citations a little bit less, but Amjur Second is going to suffer the same problems that Corpus Juris Secundum suffers. That is, they're trying to do things at a national level, and there's just no way you can cover all 51 jurisdictions intelligently. They have to make mistakes, or they couldn't tell you anything. Now, there's several other things that are worth noting about Amjur Second before we leave. This set is also kept up to date by Pocket Parts, but they've come up with an innovation. Amjur Second keeps, at the end of the set, several loose leaf binders, and these are called new topic binders. In other words, they recognize that sometimes entirely new areas of the law arise that don't fit into their pre-existing alphabetical arrangement. To accommodate that, they will actually create entirely new topics and put them in a special binder at the end. Now, the indexes will send you to these binders, but it's a way of accommodating the changing legal environment. A second thing to note about Amjur Second is, as a part of the Total Client Service Library, there is an accompanying set of form books and pleading and practice books geared to the national level, all of which are cross-referenced through Amjur Second. In the materials that accompany this tape, you'll see a list of how to plug into these sets from Amjur Second. Sometimes, if you need a form or you need guidance in finding a form, these practice sets can be very helpful. Now that we've seen the legal encyclopedias at the national level, I want to point out that some of the major jurisdictions, perhaps the state in which you live, also have state legal encyclopedias. Now, as an example, let me take California. In California, we have CalJur. CalJur is a product of the Lawyers Co-op Bancroft Whitney Publishing Company. And it is arranged very much like Amjur Second. As you might guess, it follows the same philosophy, and it's part of their Total Client Service Library. It refers you to other Lawyers Co-op Bancroft Whitney products. It arranges all of the legal topics in California in alphabetical order. But this set has a lot more power. Why? Because it can focus on California. It can recognize there are some very special things about California law, very special ways that California handles legal research and legal literature. It has a general index at the end. It is also kept up to date by Pocket Parts. In fact, let's just make this a general rule. Anytime you use a law book, look in the back to see if there's Pocket Part updating. You'll almost always find it, unless some geek has stolen it. CalJur, then, is a useful state encyclopedia. About a dozen states have these local encyclopedias, some done by Lawyers Co-op Bancroft Whitney. If so, they're part of the Total Client Service Library. Some done by the West Publishing Company. If so, they'll be part of the West Research System. And a few independently produced. I'm not going to bother reading you a list of these on the tape, but again, we've put these in the materials that accompany the tape. So look in your handbook to see if your jurisdiction has one of these legal encyclopedias. Again, this is material for lay of the land, materials for finding out the names of important cases. Don't rely on this as you would on a lawyer's advice, but use it for background. It's also worth checking with people in your own jurisdiction. In some jurisdictions, the legal encyclopedias are highly thought of. In others, there are more problems with them. Perhaps you'd best ask the reference librarian at your local law library before you dive into the encyclopedia, but be aware that it's there to help you with getting the lay of the land and to perhaps put you into a major research system. Are there other places that you might check to get the lay of the land? Well, some of the other sources get to be a little more problematic because they're getting into a level of detail that we haven't discussed yet. I should mention, however, law reviews. Law reviews are special publications that discuss legal issues. Every law school in the United States has at least one law review published as a part of its educational program. These contain long theoretical articles that discuss legal issues and follow a general format. In the 1890s, the Harvard Law Review used a certain form of publication that has been emulated by every other law review in the country. And that form is a very dry discussion with many, many footnotes. Now, contained in these footnotes are citations to primary and secondary authority. And in that sense, the law review can be a big help to you. If you find a law review article on your point, someone will have done an enormous amount of work for you. That's one of my golden rules of research. Find someone who's done the work for you. In the world of legal literature, millions of people have already attacked the wide variety of legal problems. Use their work, whether they're a publisher who's developed a publication system or an individual author publishing in a law review, they might be of help to you. Now, I want to warn you off law reviews a little bit. If you don't understand technical language, it's probably not going to be in your lay of the land section. This would be more in the focusing down area. You're going to need some technical expertise. For most lawyers and judges, reading law reviews is like listening to someone scratching their fingernails across a chalkboard. They're not enjoyable. However, if you've got the technical expertise, or let's face it, if you find an article that's right on point, that may be where you want to go. One of the nice things about law reviews is they're so easy to find. I'm holding Current Law Index, one of two major paper indexes to law review publications. Now, this comes out periodically and accumulates annually, and it covers all of the major law reviews in the United States. It arranges the articles by subject. It arranges the articles by author. If an article concentrates upon a discussion of one particular case, that's listed. If an article centers itself on one particular statute, that's listed. If we looked up sexual harassment here, we would see, in fact, a variety of sources discussing problems of sexual harassment in the workplace. Now, sometimes you'll have to play with the subject arrangement to get exactly what you need, but Current Law Index covers a wide variety of periodicals with decent natural language indexing. Is it the only game in town? No, it's not. There's Index to Legal periodicals. The Index to Legal periodicals is put out by the H.W. Wilson Company. Now, the H.W. Wilson Company should be familiar to anybody who's used a library. They produce a wide range of the traditional library indexes. If you ever worked on a term paper in high school and used Reader's Guide to Periodical Literature, it's an H.W. Wilson product. Well, Wilson publishes the most venerable of legal indexes, that is, the Index to Legal periodicals. It's been around in one form or another since the first decade of this century. It tends to be a little more formal, a little more traditional than Current Law Index. It covers a few less periodicals, but you find it in more libraries. Now, Index to Legal periodicals does the same thing. It arranges all publications in law reviews by author, by subject, and again, if the article happens to be mostly about a case, it'll list it by case. Mostly about a statute, it will list it by statute. Again, if we were looking for articles on sexual harassment, we could simply go into the Index to Legal periodicals, look under sexual harassment, and find the articles currently being published in the law review literature. Now, this comes out on a periodic basis. You have to use them back to the annual accumulations and then 3-year accumulations before that. The point is there's good indexing from two separate sources, almost one of which is going to be in every law library, and many will have both, so you can try both. The trick is, what do you find when you use the index? Beware of those law review articles. It's one of the ways people get scared off. You can find one that's useful, but they might seem too technical. A better bet, where a place that you're led to by both of these indexes, is bar journals. State and national bar groups publish their own journals. Now, these tend to be geared for practitioners, so they're not written in the highly technical academic language. It may still be difficult to read, but they will center on practice areas. And even better, if you can find in your state's bar journal a discussion of a new area of law, you'll be reading what the lawyers in your state are reading, sometimes in a very simple and straightforward manner. And because they come out on a monthly basis, often very much up to date. One of the problems with the academic law reviews is they lag very far behind in time, sometimes a year and a half. There is a third alternative in these legal periodical publications, and those are legal newspapers. There are 3 national legal newspapers: National Law Journal, Legal Times of Washington, and American Lawyer. The first 2 come out on weekly bases. They cover hot breaking areas of the law. They talk about new issues. And in fact, if you're doing research about something that you've heard about on the radio or seen on the TV or read about in your newspaper, it's most likely you'll find it first in one of these legal newspapers. Most of them are collected by major research law libraries, and all of them are indexed both in Current Law Index and in Index to Legal Periodicals. Now, both Current Law Index and Index to Legal Periodicals appear in forms other than print. Some libraries will have them in a compact disc format. That will be a compact disc that plays through a personal computer. Index to Legal Periodicals is called Wilson Disc in that form. Current Law Index is called Legal Track. But not many libraries have these yet. These are expensive arrangements. There's also an online version of both these periodicals through Lexis and Westlaw, the 2 large online databases of legal information. Now, we haven't talked about those yet, and once again, they're not generally available to the public. But when we do talk about them, remember that the indexes to the legal periodical literature, the academic journals, the professional journals, the legal newspapers, will be available online as well as in compact disc format, but still in paper. What if you still need more background? Are there other secondary tools that you can turn to? Well, there are, but to be honest, most of the rest are not in step 2 of our research roadmap. Lay of the land, finding out the major landmarks, is territory where the law reviews sometimes don't belong. The other secondary sources almost exclusively belong in level 3, and that is focusing down. Because if you don't already know a good deal about your research topic, just as you can't use some academic law review articles, you really should be careful of these other sources. Now, what other sources am I talking about? First, I'm talking about loose-leaf services. Now, loose-leaf services is one of the areas that we have a unique publication. Most disciplines don't use them the way law uses them. And what are they? Loose-leaf services are books where the editing process never stops. You are, instead of being given a bound volume of a book, you are given a loose-leaf binder. And it's possible for the publisher to continually send you new pages, so that as the law changes, rather than using the pocket part in the back of the book, now you can simply take the pages out, throw them away, and put in new ones. This, by the way, is one of the most boring jobs ever thought of in history. I worked my way through law school doing loose-leaf filing, and it called for an incredible combination of paying attention to what you were doing and being able to absorb enormously boring stretches of time. Replacing these individual pages is very tedious, but it is very effective. It means that the loose-leaf service that's updated on a weekly or monthly basis stays current. The problem with these loose-leaf services is they tend to be very focused. If you don't know a good deal about your information area, they're probably fairly dangerous places to be. They feature complex indexing, often in layered format. They have integration of statutes and cases and administrative rules and regulations. Now, this means they can be very powerful in solving your research problem, but by the same token, rather difficult to use and somewhat dangerous for the novice. Your first trick will be finding, is there a loose-leaf service in my research area? There are several ways to find this out. You can simply consult the card catalog in your library or the computerized catalog if it's online. Probably your best bet is to talk to a reference librarian. If you know the area in which you're working, they may be able to direct you to an existing loose-leaf service. There is a publication called Loose Leafs in Print, which is a subject listing of all loose leaf services. So if you know your subject and you want to find out, is there a loose leaf service published in my topic area, you can check. Usually this tool is kept at the reference desk in the library. You should ask there. It's renewed every year or two, so it stays up to date as well. Now, there are several major publishers in the loose leaf area that are worth knowing about. Commerce Clearinghouse, popularly called CCH, is one of the major publishers of loose leaf services. And they will have a subject-oriented loose leaf service in almost every major practice area. Another name that you'll hear a lot is Prentice Hall. That's abbreviated PH. Prentice Hall and Commerce Clearinghouse often compete so that you'll find a set done by each in each subject area. The third major player in this game is the Bureau of National Affairs, abbreviated BNA. Now, they tend to produce a different kind of loose leaf service. What I've described up till now are services where the book is continually being edited, pages taken out, and new information being put in. The Bureau of National Affairs does that a bit, but most of their sets tend to be current awareness sets. These are sets designed to tell you the most recent information. And so instead of taking out pages and putting in pages, you simply put new material at the back of each tab in your binder. We'll look at a few of these sets as we work through the rest of the research diagram. The important thing here is be careful. In using loose leaf services, I can only give you one major piece of advice. That is, one of my golden rules of research: read the directions. Now, I know that sounds stupid, but in fact, it's one thing that many researchers fail to do. Every loose leaf service will have a section in it that says how to use this service or how to use this set. It's usually in volume 1, or if it's a multi-volume set, perhaps in the index volume at the end or the beginning. In that tab, the publisher, whether it's CCH, Prentice Hall, BNA, or any of the smaller publishers who also enter this field, will tell you, here is what this set does. Here is how we arranged it. Here is how the indexing works. If you actually spend the 10 minutes to read that section, you'll probably be a more effective user of that set than the average lawyer. You have to remember that the loose leaf service company has sat down and tried to figure out how to put the material together. What you should do is find out the system they were using. So please, in all your research, but especially in loose leaf services, read the directions. What other secondary source materials are there that you might find yourself looking at? Well, at this point, I think what we have to do is start looking at the secondary source materials that work closely with the primary source materials. So I think we're now moving from step 2, lay of the land, all the way into step 3, focusing our research. And I think that it's time on our research diagram that we take a serious look at the primary sources themselves. Now, so far, we've been talking about the materials that live on the friendly side of the legal research spectrum. Secondary sources that take you by the hand and help you out. The kind of tools that you meet in step 1, step 2, and part of step 3 of your research roadmap. But it's time that we get closer to those primary sources, the bugaboos of legal research, the tools that scare people the most. To do that, we're going to have to leave this comfortable setting with its roaring fire. We're going to have to go to the library and get serious. I'm going to try to give you a great deal of information in the next segment of this tape. Some of it might seem to come thick and fast, but that's because I want you to know as much as possible. Use the handbook that comes with the tape. That's why God gave you a pause button. Stop me when I talk too fast. I know I talk too fast. It's just I've got so much I want to tell you. But it's time to get serious, folks. Let's roll up our sleeves and head to the library. Come on. So here we are back in the library to talk about the serious part of the research spectrum, the primary sources. This is the stuff of the law itself, the raw law. Now, what's at the top of our 4-part diagram of primary sources? Constitutional law. At the federal level, there's no problem in finding the federal Constitution. It's everywhere. During the bicentennial, I think they even printed the thing on Wheaties boxes. And goodness knows it doesn't change very quickly, so there's no problem of updating. Finding the text of the Constitution is no trick. What we have to find is what the text of the federal Constitution means. And for that, you have to go back to secondary sources. There's just been too much debate about constitutional interpretation over the last 200 years. In the material that comes with this tape, we'll discuss some of my favorite constitutional finding tools, but they're all going to live out on that secondary part of the spectrum. As we work through some of our legislative materials, I will tell you places to find the annotated constitutions, but I don't like using them very much, to be honest with you. What about state constitutions? State constitutions are different. Some of them are like the federal Constitution, short and infrequently amended, but some of them are quite lengthy and are amended frequently. You're going to have to check in your own jurisdiction. But when we talk about annotated codes in your jurisdiction, feel comfortable in knowing that there will always be an annotated form of your Constitution as well. So, no problem in finding federal or state constitutional materials. Let's look at the second rung in the primary sources, legislation. Legislation suffers from all of the problems of any other research tool. It has to be in 51 separate jurisdictions. There's no way I can help you memorize how the legislature in your particular state works. There's too much variation. But I can give you a pattern. A three-part diagram for legislative publication that you can apply in any jurisdiction throughout the United States. The three steps are: first, session laws; second, codes; third, annotated codes. Now, what does each of those steps mean? A session law is a collection of all of the newly enacted laws of your jurisdiction, of your state, or of the federal jurisdiction. They're just collected together in an annual volume, published usually in chronological order. This volume is done by the jurisdiction and usually has a pretty decent index. Sometimes it is in fact the official form of the law. Now, they may not call it a session law. Every jurisdiction has a different name for it, but some tool will serve this function. The problem with session laws is they come out too slowly. A second problem is they don't cumulate. And when I say cumulate, I mean they don't bring information together. Think of an example, our sexual harassment example. If you wanted to find all the laws on sexual harassment in your state, you could go to each volume of your state's session laws and move from volume to volume, looking in the subject index. Some of these session laws will even have tables in them that will tell you laws that are repealed, laws that are amended. But you'd be keeping track of volume after volume. That's just too tedious. And in an area like sexual harassment, where there might be a great deal of legislation, it's going to be too much trouble to do all of that bringing together on your own. So every jurisdiction has the second level in our diagram, some form of a code. Now, what is a code? A code is the subject arrangement of all of the general in-force legislative material in your jurisdiction. Someone's gone back through all those session laws and pulled out the laws that are still in force and grouped them by subject. It doesn't matter what subject. All they have to do is arrange them in some subject order. Now, some states use a few very large subject groupings. Others, many particular ones. This is going to vary from state to state. The point is, everybody has done it. Everybody has organized their law by subject. Usually, these state codes have pretty decent natural language indexes, so that if we wanted to find where they had put all the laws on sexual harassment, you could go to the general index volumes, look under sexual harassment or some variation, and get sent into the topic or title and section where you could find your laws. Now, why aren't codes enough? Well, for one thing, they are often done by the jurisdiction itself, and jurisdictionally sponsored publications are often slow. Many states have done codifications but haven't gone back and looked at them in years. Secondly, if you're using legislative materials, it frequently is not enough to see the language of the legislation itself. In modern legal practice, you have to see what the courts have said about legislation if you stand any chance at understanding it. Sometimes legislation will be drafted poorly. Sometimes, intentionally, they will put in ambiguous words, allowing the courts to decide what those words mean. Let me give you an example of that. I'd like to read Section 399 of the California Penal Code to you. Listen to this language. Death from mischievous animals. If the owner of a mischievous animal, knowing its propensities, willfully suffers it to go at large, or keeps it without ordinary care, and such animal, while so at large, or while not kept with ordinary care, kills any human being who has taken all the precautions which the circumstances permitted, or which a reasonable person would ordinarily take in the same situation, is guilty of a felony. Think of those words. Words like reasonable, willfully, mischievous, ordinary care. What do these words mean? You're going to have to turn to the decisions of the courts to find that out. That's one of the relationships that the courts have to legislative material these days. They interpret and give meaning to the words in statutes. That means that you have to see the decisions of courts if you stand any chance at understanding what legislation means. And that's why we have the third part of our diagram, the annotated codes. Annotated codes reprint the information of the state code, but now after each section of the code, they provide for you summaries of the cases that interpret that section of the code. Now, they're not going to print the entire case, but there will be summaries of the cases, cases that interpret or criticize or expand upon that particular section of the code. Now, they give you other information as well, because these are commercial publications. Annotated codes are done by profit-making enterprises. The large publishers, like the West Publishing Company of St. Paul, Minnesota, like Lawyers Co-op, Bancroft Whitney publishers, they do some state codes. There are third-party publishers as well that do state annotated codes. The point is, as private publishers, they're going to try to help you as much as possible. They're going to try to give you as much information as they can. They'll send you to law review articles. They'll send you to form books, to how-to books. They'll also put you into their research system. Obviously, if it's a West product, they'll put you into the West research system. If it's a Lawyers Co-op, Bancroft Whitney product, they'll put you into their research system. If it's a third-party publisher, they'll do everything they can for you. They also try to keep these things up to date. They use pocket parts in the back of the volume to keep it up to date on an annual basis. They will frequently have pamphlet supplements that sit at the end of the set for quarterly or even monthly updating of your material. They also frequently have excellent indexes. That's why I love annotated codes. They're one of my favorite research tools. They integrate material. They pull it together. You can go into their general, usually natural language index, find your topic like sexual harassment, and be sent to the relevant legislation. And then what do you find? Not just the legislation, you find the cases that interpret it. You'll be sent to administrative rules and regulations issued under it. You'll be sent to secondary sources and put into a research system and then brought all the way up to date. Annotated codes are one of my favorite places to start research. They should be understandable and manageable to everybody, and there's an annotated code for every jurisdiction. Now that we've talked about our three levels of publication, session laws, codes, and annotated codes, let's take a look at the federal example. How does the federal government handle this? Is there a session law at the federal level? Well, yes, there is, and it's called Statutes at Large. Statutes at Large is an annual publication of the federal government. It publishes all of the newly enacted legislation, public and private, from the federal jurisdiction. Now, what do I mean by public and private? Well, there are some private laws. Private laws are laws that are pointed towards an individual or a specific group, often in response to a claim made against the government, or perhaps an immigration or naturalization matter. Public laws are laws that apply to everyone. The public laws in Statutes at Large are numbered using the public law numbering system, PL numbers. The first part of that number indicates the Congress in which the legislation was enacted. The second part of the number simply the order in which that bill became law. We've pulled this volume of Statutes at Large as an example of what we're talking about. In here you'll find Public Law 95-555. That means the 95th Congress enacted this piece of legislation. It was the 555th law enacted. They're just in chronological order, not any subject arrangement. You can see this amends Title VII. It's about sexual harassment and job discrimination. Look at these two pages and you can see an array of information. You see the original bill number from when the legislation was introduced in Congress. You can see some indication of legislative history information at the end of the second page. You can even see where the bill will eventually be put in the United States Code. And notice, parts of this statute at law printing will go to different parts of the United States Code. That'll be important later. This is an excellent set. It's got a good subject index. Statutes at Large even has tables which will tell you what laws it amends, what laws it repeals. It has all the problems of any other session law, however. It doesn't accumulate and it comes out too slowly. So at the federal level, we have a second tool, United States Code. U.S. Code takes all of the laws that are general and public in application at the federal level and organizes them in 50 subject areas. Now, it doesn't have to be 50. Those were just chosen in 1926 when U.S. Code was begun. Some of them actually have no laws in them at all, but we've stayed with the same 50 subjects. U.S. code comes out every 6 years, entirely reprinted. They don't change the subject arrangement, but they accumulate or bring into the set all of the new law every 6 years. In the intervening years, they issue supplement volumes that do bring all changes together. So you look in U.S. code under your title and section, then you look in the supplement volume to bring yourself up to date. U.S. code has an excellent general index that's done in pretty good natural language. If you wanted to find laws about sexual harassment, you could do it. Go to the general index of U.S. code, look up your topic, get referred into the set. Why isn't it enough? It's not enough because it suffers from the same problem that any code volumes suffer from. It just comes out too slowly, and it doesn't integrate those materials for you. It doesn't give you the cases that you need and the other information, and it doesn't put you into a research system. So at the federal level, we've got 2 different publishers who compete at the 3rd level. 2 annotated codes. That's the 3rd level of statutory publication, our annotated code, and here we have 2 of them, U.S. Code Annotated and U.S. Code Service. Now, U.S. Code Annotated is put out by the West Publishing Company, and as such, it follows the West Publishing philosophy. U.S. Code Annotated gives you comprehensive coverage. That's what the people at West think you want. They think you as the researcher are saying, give me everything. Give me every case that has ever touched upon my statute. And that's what U.S. Code Annotated tries to do. They will give you every case that is ever mentioned, ever referred to, ever criticized, commented upon, or even peripherally touched upon your case. It will also put you into the West research system. If there's a topic and key number that leads you into the digest system, something we'll talk about later, it will give you that topic and key number. They'll send you to form books, to law review articles, putting you into a research system. Now, U.S. Code Annotated is kept up to date by pocket parts in the back of the set. It's also got pamphlet supplementations at the end of the set to keep you even more current. It's got a great general language index at the end of the set and some useful tables. If you only know the name by which your act is popularly called, and we're not talking popular like on Entertainment Tonight here, we're talking popular like a court refers to it by that name, there is a popular name table. If you only have a statutes at large site and don't know where to look in the code, there's a table to do that for you too. U.S. Code Annotated does have some problems. One of the problems is that by giving you citations to every case about your particular part of the U.S. Code, they sometimes overload you with information. They sometimes give you too much stuff. And that's one of the criticisms of U.S. Code Annotated. But it is a powerful tool. It also has an annotated Constitution set. There are volumes of the United States Constitution that print all cases interpreting the sections of the Constitution. This is truly information overload, though, and I don't advise you to use those. Well, now, what's your alternative set? U.S. Code Service. U.S. Code Service is published by the Lawyers Co-op Bancroft Whitney Publishing Company, and they use a different publication philosophy. Their idea is that you, as the researcher, are saying, give me the important cases. This set started in the 1970s, and it reflects the slight change in research philosophy. U.S. Code Annotated started in 1926. It's a more traditional set. When this set came on the market, it was marketed under the following guises. First, we will select the important cases. We're not going to give you every case. We'll just give you the cases that matter. Secondly, we're going to give you citations to administrative rules and regulations that are published under your legislative section. We'll send you right there. Thirdly, we're going to put you into a research system. Now, in fact, U.S. Code Service has been so successful at doing this that they have, in the intervening years, made U.S. Code Annotated react, so that U.S. Code Annotated now does some of these very same things. But U.S. Code Service still does them in greater measure. This set is also kept up to date by pocket parts. It's also supplemented by monthly pamphlets. It also has an excellent subject index at the end. U.S. Code Service and U.S. Code Annotated do the same basic function. They provide all federal law and make it accessible to you. And they integrate it with the cases so that you find your raw law in the statutes at large. It gets organized in the U.S. Code, and then the U.S. Code Annotated gives you cases in a research system. U.S. Code Service gives you cases and a different research system, each having their own research philosophy so that you get slightly different approaches. Let's walk through an example. Let's see how U.S. Code Annotated handles our matter of sexual harassment. Remember Public Law 95-555. How does that appear in U.S. Code Annotated? If you look, you see the language of the statute. At the end of the statute, what do we find? Annotation after annotation. Summaries of cases that tell you how the matter has been handled, with the full citation that would allow you to go read the whole case. You can see that we're put into the West Research System. Here are guide maps. And of course, you should always check the pocket part and the supplementation. Now look at the same section as it appears in U.S. Code Service. It's the same Title 42 of the U.S. Code, the same Section 2000E. It's the same underlying legislation, 95-555. Now sometimes you actually do find a slight variation in the language here. That's because U.S. Code Service will exactly give you the statutes at large language. U.S. Code Annotated follows the Congress in sometimes harmonizing this language. But what's important is what you find at the end of the printing, and that is the summaries of cases. There are fewer here, but they tend to be longer. Look at the research guide in the U.S. Code Service. It sends you into the Total Client Service Library. That's the Lawyers Cooperative Bancroft Whitney Research System. They are longer in listing, giving you more inputs into secondary source materials. If you've got both of these sets available, use both. If you only have one available, be sure you update correctly and get the most out of your set. But please, if you're looking for federal legislative materials, remember statutes at large, to the U.S. Code, and then to the two integrating annotated codes that exist at the federal level. What about state compilations of statutes? Every state is going to follow this same pattern. Every state will have some form of session law. They won't call them session laws always. Each state will have its own nomenclature, its own name for the set. But there will be some set serving this function, some set that publishes chronologically every new piece of legislation passed in the jurisdiction. Every state's going to have some form of codification, and every state's going to have some form of annotated code. Some of them will be done by West, some by Lawyers Co-op, some by other publishers, but there will be one for your jurisdiction. In the materials that come with the videotape, we've listed these so that you can go and look it up. But when you find the set, you'll know what you're looking at. All the annotated codes have general indexes and integrate materials. Now, one other form of state publication that deserves mention is municipal ordinances. Every city has its own ordinances that govern the action of a city. And sometimes these are very important to you, but these are not collected in the big standard sets. Cities vary enormously in how they publish this information. You're going to have to be clever about how you find it and how you put it together. That's the second primary source, legislative materials. Legislative materials have a fine pattern to organize themselves around. In fact, I've done this part of our videotape in front of the full array of federal legislative materials. Along this wall, we'd find session laws, U.S. Code, and the two annotated versions. You might find federal materials or state legislative materials arrayed just like this in your law library. Unfortunately, the next rung in our hierarchy, administrative rules and regulations, don't have this good an organizational system. We're going to have to go elsewhere to talk about them and how they fit into your research picture. Now, at the beginning of this video, I talked about how important administrative rules and regulations are. But it has been the most recent area of growth in legal publication, and therefore, it's the least sophisticated. There's not a good general pattern that I can give you. I think the best way to approach this one is to look at the federal situation and then talk about the states and how they relate to that. At the federal level, we have a codification of all general federal rules and regulations. It's called the CFR. The Code of Federal Regulations gathers together all of the rules and regulations issued by federal agencies into 50 titles. Now, you might think that's great. The same 50 titles, Bob, that we saw in working with the U.S. Code. Well, legal research is never that simple. We always want to keep you as confused as possible, so it's not exactly the same 50 subjects. There's some slight differences. And there's an important organizational difference. That difference is that the 50 titles here are really a grouping of all federal agencies by subject. Each agency has all of its rules and regulations in one place, in the 50 titles. Now, the CFR, or Code of Federal Regulations, is issued once a year. The entire set should be replaced during the course of the year. And the schedule is that each 3 months, 1/4 of the set is replaced, and each year they're given this distinctive color. Doesn't always work. As with so many government publications, the CFR often falls behind. But you can easily tell what the date of effectiveness is of your CFR volume simply by looking at the front. On the front of every CFR volume, there'll be a phrase that says revised as of, and then it will give you the date of the last revision. Here we have January 1st, 1989, so that you know that for the topic of banks and banking, this is all the rules and regulations as they stood January 1st, 1989. Now, if you said, Bob, what if there were older rules? What if I'm dealing with a problem that happened in 1983? How do I know what the rules and regulations were in 1983? There are tables in the back of each CFR volume that tell you historically when changes were made, so that you can go backwards in time and see if you've got a citation to a title and a section in the CFR, what the law used to be. How do you find the right section and the right title in the CFR? Well, there is a general index at the end of the set called Finding Aids. Now, this is one of the worst topical indexes that we have. They've worked very hard in recent years to make it better, but it still has a lot of problems. That's one of the reasons loose leaf services came to be such powerful research tools. Loose leaf services tended in their early years to concentrate on administrative law areas. It was the loose leaf publishers like Commerce Clearinghouse and Prentice Hall who organized administrative law, published it, indexed it, and made it accessible. CFR is a better index today, but for some of these titles, you still have to rely on the secondary source material. Now, what if you do find the right title and section in the Code of Federal Regulations? We've seen that the volume I hold is good as of January 1st, 1989. What's happened since then? Well, there is a simple way of updating it. You update it through what I call a notice publication. That publication is the Federal Register. The Federal Register comes out 5 times a week. It's one of my favorite federal publications. Why? Because so many people are afraid of it. There's nothing to fear. I also like it because it's one of the few legal research publications that made it into a State of the Union address. When President Reagan took office, he viewed the Federal Register, a record of all new federal administrative rules and regulations, as one of the epitomes of all that was wrong with the Washington infrastructure. He pledged to reduce it, and in fact he did. During the Reagan presidency, it shrunk from 100,000 to about 50,000 pages a year. But think of that. 50,000 pages of new and proposed federal rules and regulations. That alone is testimony to how important administrative law is. The Federal Register then, 5 times a week, publishing all the new and proposed federal rules and regulations, can be used to update the Code of Federal Regulations. The thought is that everybody in the United States is on notice as to everything that appears in here. So I guess the concept is that we're sitting down over our cornflakes reading this every day. Well, even if you don't do that, the legal presumption is that you do. How can you tie these two tools together? How do you tie together the Code of Federal Regulations and the updates in the Federal Register? Well, that can be done through a tool called List of Sections Affected, or LSA. List of Sections Affected allows you to look up your title and section in the Code of Federal Regulations and see if anything has changed. And if something has changed, it will give you the specific page site in the Federal Register. Brings you almost up to a daily update. Now, I know that sounds like a confusing process, and we put an example in the handbook that accompanies the tape. But I thought it would be worthwhile to tie this whole system together by going back to our sexual harassment example. Remember when we looked at the session law at the legislative level? We looked at Public Law 95-555. That law amended a section of Title 42 of the United States Code Annotated, the example that we showed you in U.S. Code Annotated and U.S. Code Service. So here you've seen the raw law put into the annotated code format. From those annotated codes, we can move to the Code of Federal Regulations, because there are rules and regulations that apply to Title 42, Section 2000E, where Public Law 95-555 came to rest. Those are in CFR Title 12, the one we've been looking at. And here you can see regulations issued under the statute. If we went to list of sections affected and looked up our regulations, we can see references to Federal Register pages that updated. So you can see that there is a stream of information here. We're looking for sexual harassment information. We see it in the session law form at the federal level. It gets codified at the federal level. It goes into the annotated code at the federal level. It comes out through the administrative publications at the federal level. The same information passing through different forms, creating different law, all in the primary source area. Now, what does the administrative law situation look like at the state level? Well, unfortunately, this is one of the last frontiers of legal research, one of the last places where you don't have a great deal of help. Some states have a tool that looks very much like the Code of Federal Regulations, that organizes all state rules and regulations by topic and keeps it up to date. Some states have a notice publication, something where they put all new rules and regulations, and some states still have almost nothing. We have put a list in your handbook of the situation in each of the 50 states. Now, the situation is fluid. It keeps changing, so don't rely on this. This is one of those situations where you should use one of my golden rules of research and consult a human being. When you go to the law library and you need administrative rules and regulations from your state, ask a reference librarian. Literally, this situation is changing almost daily. That's the third rung. We've now seen constitutions, we've seen legislation, we've seen administrative rules and regulations. What lies in wait for us now? Case law. You know, I thought long and hard about this subject. When should I discuss cases? Should we put it at the very beginning of this videotape, when you were fresh, when you were eager, when you were excited? Should we put it in the middle, when we'd explained a few things and before we got to some of the goodies? Or should we save it to the end? I decided to wait till the end, to wait till we had taken you through the secondary sources, equipped you with some of the tools of research, made you feel comfortable with statutory materials and administrative rules and regulations before taking on the hairiest bear of them all, case law. Now, how am I going to explain case law to you? I'm going to come at case law from every possible direction. I want to first explain to you what a case is, so that you understand what it is we're working with and why it's so hard. To do that, I want to use another pattern, a pattern that's going to apply to every one of the 51 jurisdictions. It's my three-step court diagram. Trial court level, appellate court level, and court of last resort level. Every one of the 50 states and the federal jurisdiction is going to have some form of this three-part court diagram. They are not going to all call them by the same names. That's going to vary from state to state. But what they will have is functional equivalence. Now, what do I mean by functional equivalence? There will be something that serves as a trial court. What happens at the trial court level? Two different types of issues get resolved at the trial court level in every system. Issues of law and issues of fact. To make this a little easier to understand, let's take an example, what law professors love to call a hypothetical. Let's say that in preparing for this videotape, I knew that I was going to have a chance to explain to you how to do legal research, and I wanted to do it in the best way possible. I was so worried I went to a local cafe and loaded myself up with cappuccinos to bring my mind to bear on the problem. I was walking back to the law school when I was hit by a Lamborghini. Now, let's say that Lamborghini was driven by Oprah Winfrey. Let's say that I want to sue her for $1 million and that I contend that she was speeding, she wasn't looking at the road, she was fixing her makeup in the rearview mirror. Let's say that Oprah contends I was not in the crosswalk, that I was weaving bizarrely, and that when I saw her car, I threw myself in front of it screaming, "I hate talk shows." What we have there are some issues of fact. Was I in the crosswalk? Was I inebriated? Was she exceeding the speed limit? Was she looking in the rearview mirror? Issues of fact. And those issues of fact are going to be locked in at the trial court level by the trier of fact. Now, who's a trier of fact? Is that a jury? Could be. In some jurisdictions, you use a jury in some matters. Could be a judge. That varies as well. The point is that the issues of fact are locked in. Now, of course, there's exceptions to this. Trust me. Everything I tell you has exceptions to it, but the general rule is issues of fact locked in. But there might be other issues, issues of law. Now what do I mean by those? Let's say that the matter of whether I was intoxicated or not was in dispute, and that I had taken a breathalyzer test after the accident. Maybe there would be a dispute about what the legislation defining inebriated or drunk in California really is. Let's say that there's a dispute over what a crosswalk really is. Let's say that we have an evidentiary dispute. Let's say that Oprah's attorney tries to call my mother as a witness, and my mother testifies that throughout my entire life I've had a habit of throwing myself in front of expensive Italian sports cars. My attorney might leap to his feet and say, "I object, Your Honor. That should not be allowed in evidence." These type of questions are questions of law, and questions of law are not necessarily locked in at the trial court level. It is questions of law that can be appealed to the second and third rung in our diagram, the appellate level and the court of last resort level. Now, this can get tricky because trial courts in some jurisdictions are broken down different ways. They might be broken into family courts and criminal courts or small claims courts. They might be divided up by the amount of money in dispute. So sometimes a trial court level will be a trial court and an appellate level at the same time. The point is, look for the functional equivalent. And the real point here is that the trial court proceedings are not the cases that we're talking about. The cases that we're talking about are the issues of law when they're appealed to the appellate and court of last resort level and when they result in a written judgment, because that's what cases are. Written resolutions of issues of law at the appellate or court of last resort level. Again, we got exceptions, but that's the general rule, and that's why these things are so boring. Gosh, I remember being in law school, and you'd read some steamy case full of real emotions with people busting at the seams, and it would never get resolved. We'd read the case, and you'd never find out. You know, one of the standard questions in a law school classroom after you read the case is who is suing who. You can't even tell who the parties are. That's because all of the guts have been squeezed out of the case, and all that's left are the issues of law. So that's what we're dealing with, written resolutions of issues of law. Now, how do these things come to be published? Well, there are two forms in which you tend to find them published, official and unofficial. Now, what do I mean by official? I guess official is what you would instinctually think of. That is, that the jurisdiction in which the courts operate officially publish the cases. That we would hire someone and tell him or her, gather the cases together, put them in an official form, and publish them for everyone to read. Oddly enough, that is not always the case. 1/3 of the states don't have official publications. Even at the federal level, only the court of last resort, we'll see, has an official publication. Why is that? It's because the official publication of decisions encounters the same problems that other official publications encounter: sloppiness and lack of speed. In fact, they were so slow as early as the 19th century that a whole family of competing publications grew up. That family comes from the West Publishing Company of St. Paul, Minnesota. There's that name again. Because John B. West, one of my favorite historical characters, recognized in the 19th century that lawyers needed a better system for getting cases. And West started that system. He went to individual jurisdictions and found the cases himself. He published them faster, in greater numbers than the official reporters. He's done such a good job at it that he and his company over the last century have come to dominate the field. The West National Reporter System publishes decisions from every state and at the federal level. Every case that appears in an official reporter will also appear in a West reporter. Cases that don't ever appear in official reporters do appear in West reporters. That's why West, with its regional reporter system, has become so dominant and so important. How did West do it? He divided the country up into 7 separate regions. These geographical divisions reflect the way someone sitting in St. Paul, Minnesota in 1880 thought about the United States. You can see that John B. West was a publishing visionary, but the guy was no geographical genius. He thought that everything out west was one big clump. It's good trivia to play with lawyers to ask them what region Oklahoma's in, because John West is the only person I know of who thinks of Oklahoma as a Pacific state. The idea in grouping them geographically was that he could get enough cases to get out an advance sheet on a bi-weekly basis. Now, what's an advance sheet? An advance sheet is simply a pamphlet that publishes cases before the eventual bound volume occurs. And the beauty of this pamphlet is it has the pagination that the eventual bound permanent publication will have. Getting these advance sheets out quickly allowed John West to get information to lawyers systematically and inexpensively. By dividing the country into the 7 regions, he could cover everything. Now, the country tricked him. New York and California produced so many cases over the years, they overloaded the regional reporters. California, which is in the Pacific region, was sinking the Pacific. New York, which was in the northeastern region, was destroying the Northeast. So each was given its own separate publication. For California, that's the California Reporter. For New York, it's the New York Supplement. The California Reporter has the upper 2 levels of the California court system. The New York Supplement, the upper 2 levels of the New York system. Only the court of last resorts from those 2 jurisdictions now go into the regional reporters that cover them. So that means you really need 9 sets. The 7 regional reporters, the California Reporter, and the New York Supplement to cover every one of the 50 jurisdictions. In a little while, we'll take a look at the federal system, and you'll see West covers that too. So we have this massive system of unofficial reporting of decisions paired with the official reporting of decisions. But we still haven't answered the most basic question, and that is, when you find a decision, what is it that you found? And what I'd like to do is take a case reporter and look at a typical case so that you can get a feel for the kind of features that are common to any one of these court reporters. Now, as an example, we've picked a case on our theme of sexual harassment, and that's the landmark case of Meritor Savings Bank versus Vinson. We're looking at it in the Supreme Court Reporter version. That's published by the West Publishing Company. It's the unofficial West version of the court's decision. The very first thing we see at the top of the first column is a list of numbers and letters. 477 U.S. 57, 91 L.Ed. 2nd, 49. Now, what does that mean? That is what we call a parallel citation. It's telling you that the same case appears 2 other places. An official citation that we'll see in a second, and another commercial set. It would be exactly the same words of the court appearing in 2 totally different publications. Why do they tell you that? For research convenience. They recognize that you may want to see the other version. Now we have the names of the parties. Meritor Savings Bank, FSB, petitioner, versus Michelle Vinson et al. The names of the parties are going to be crucial in locating cases, but sometimes the names switch around. Remember Oprah and I going at it in court. At the trial court level, let's say, and wouldn't it be nice, that I recovered $1 million in suing Oprah. That would be Bearing versus Winfrey. If she brought an issue of law to dispute at the appellate or court of last resort level, that, in some jurisdictions, would change the order of our names. Now it would be Winfrey versus Bearing, so that sometimes these party names can shift. And in different jurisdictions, that is, from state to state, what you call the parties will change. Sometimes the party listed first is the plaintiff, the party listed second, the defendant. Here, the party listed first is called petitioner, and that's because this is a U.S. Supreme Court case, and you petition the court in this type of matter. Some places it will be appellant and appellee. It changes. The trick is, remember, that the order of the parties' names may switch around when using the case tables that we'll talk about in a few minutes. Below the names of the parties here, we have number 84-1979. That is a docket number. Don't worry about that. That's an internal number assigned by the court for their own record-keeping purposes. Now, occasionally, you'll need that number because you might have to get in touch with the court, and that may be how the court has filed the backup materials in this matter. But in general, don't let it throw you. Beneath that, you see another piece of information. Argued March 25th, 1986. Decided June 19th, 1986. Remember, we're dealing with decisions from the appellate and court of last resort levels in our 3-part court diagram. These are not matters where you have witnesses and juries. You have lawyers arguing, usually to a panel of judges. It's the oral arguments of the attorneys and the briefs, that is, the written documents that they represent, which will be considered by the court. We're not talking about factual issues here, just legal issues. Beneath the date of argument and decision is a long paragraph. The technical jargon for this is a syllabus. What is a syllabus? It's a description of everything that happened in the case. A reporter of decisions, an editor working at the West Publishing Company, has sat down and tried to give you a summary of everything that happened here. And in fact, this is an excellent summary of everything that took place in Meritor, where the case came from, how it proceeded, and where it ended up. This was not drafted by the judge that wrote the opinion. It isn't primary source material. It's an editorial enhancement that comes from the West Publishing Company. But it can help bring you an understanding of the decision. Then we find out it was affirmed and remanded, and the names of the justices who filed opinions. Now look at the second column, and we see the beginning of a series of numbered paragraphs. The technical word for these are headnotes. Now what are headnotes? Each headnote is a distinct issue of law that was resolved in this case. The editor at the West Publishing Company has sat down and read this decision, and he or she has attempted to isolate each specific issue of law that came up here. Now, some cases will have one issue of law, but they might have 5, they might have 10. I once saw one that had 166. Now, drawing up these headnotes is not a science, it's an art form. And here the editor has done his or her best to isolate and aid you in understanding each of these issues of law. And there'll be a short summary of each one. The numbers will correspond to parts of the text. If you read Headnote 3, for example, and found that especially useful, you could go into the text of the case, and that 3 would be sitting next to the part of the text the editor was reading when he or she wrote that headnote. Now you notice some other things here. After each number, we have a topic, a small key, and a number. That's the topic and key number assigned by the West editor. That's part of the West research system, and we'll talk about that in a few moments. But for now, remember, almost every case you see will have some form of syllabus, a summary of the decision, and some form of headnotes. Now you'll notice there are 11 separate headnotes in this case. After the 11th headnote, we see another syllabus. Well, what's going on here? Remember, this is a West publication. It's unofficial. West realizes that a researcher might want to know what the official reporter of decisions, the person directly employed by the U.S. Supreme Court, did to this opinion. And so they give you the advantage of seeing that too. They publish the official syllabus prepared by the official reporter at the Supreme Court of the same case. Now, that official syllabus also is not primary source material. Only the written resolution of the issue of law by the judge serves that purpose. But this is another way of editorially enhancing the product, trying to make it easier for you to understand. So in this case, you have 2 completely different syllabuses of the same case. And in fact, you'll see at the end of the syllabus 2 long numbered paragraphs. Those are the 2 headnotes written by the official reporter. And this is a terrific demonstration of the fact that headnotes are an art form, not a science. The West editor had 11 brief ones. The U.S. Supreme Court editor had 2 long ones. It's the same case. Then we have the names of the attorneys involved. This usually won't be important to you in basic research, but at some point it might be useful to contact an attorney in a matter to find out about background information. After the names of the attorney, you see Justice Rehnquist delivered the opinion of the court. When you get to the opinion part of a decision, what might you find? Well, there are actually 5 types of information that you might encounter. You might find the majority opinion, a concurring opinion, a dissenting opinion, a per curiam opinion, or an order of the court. Now, what do those mean? The majority opinion will be the first opinion listed. Remember, here the lawyers are arguing generally to a panel of judges, perhaps 3, perhaps 5. Here we have the United States Supreme Court, where there are 9 justices. Now, it could be that the 9 justices will all agree. In that case, it will be a unanimous opinion. They'll appoint 1 justice to write the opinion. He or she will sign it, and it will stand for the court. But sometimes they do not agree. And if they do not agree, the majority rules. 5-4 does it, 6-3, 7-2, 8-1. All of those would constitute majority opinions. If you get a majority opinion, it will be listed first. That is where the primary source is found, in the majority opinion of the court. Well, what's the second type of opinion you might find? A concurrence. Well, what is a concurrence? In this situation, 1 or more of the judges or justices say, we agree with the result between the parties, but we don't agree with the reasoning that the majority of the court uses. Well, now, why would they care about that? They care because of our common law system. What we look to is the reasoning used in the case. The same matter might come up between two parties in the future on a slightly different set of facts. You go back to the reasoning used in this opinion and draw analogies to other situations. That means the reasoning is actually more important than the result. The result is only important to the two parties. The reasoning could be important as the source of primary law for the future. Therefore, it's worth noting that you agree with the result, but not with the reasoning. A judge might list him or herself as concurring, or might actually prepare a concurring opinion, as is the case in the Meritor decision. Now, what's the third type of thing? A dissenting opinion. Now, that's much clearer. You simply don't agree. You don't agree with the result or the reasoning. Once again, a judge or justice might simply list his or her name, or they might file an opinion to that effect. Now, what are the other two? What is a per curiam opinion? A per curiam opinion is a case where the court wants to act as a group in a summary fashion. They don't want an individual judge or justice to write an opinion. They want to anonymously dispose of the matter. They're usually short, and they usually deal with well-settled areas of the law. For some reason, the court simply wants to take care of this matter and not make a big fuss about it. The fifth level orders of the court. Well, now, these aren't really opinions at all, but I put them here because they're so important in research. Remember, we're dealing mostly with things from the appellate and court of last resort level, not the trial court level. And that means that these courts can have an impact simply by refusing to hear a matter. It's one of the most frustrating things in legal research. You'll read in the paper or see on the television, a court decides that corporal punishment can be used in schools. You'll go to the library to read the case, and it isn't there. And the reason it's not there is that an appellate court or a court of last resort has simply said, we refuse to hear the appeal, the decision below stands. And if that came out of a trial court, there might not be any opinion at all. Now, the court will record orders in the court reporter, so that you can always find an order of the court. There just may be no opinion attached. Now, before I leave the example of the Meritor Savings Bank, let me take a few more glances at this case reporter so that we can see some of the other standard features that you'll find. Case reporters not only contain the reports of decisions with the editorial enhancements, they have other access tools. There will be a table of cases in this volume. It will be an alphabetical list of every case that appears inside here. This particular volume also has a statutory table, telling you every statute that's interpreted by a case in the volume. This one also has a subject index that arranges the cases according to the West subject ordering system. This volume even contains a picture of the United States Supreme Court. I want you to see these features because I want you to be able to walk into any law library, pull down any court report volumes, and understand what's in there. It's the decisions of the courts in one of those 5 forms, the editorial enhancements we've looked at, and some of these extra features. There's no mystery here. The last piece of mystery that might remain in using them is how to read a case citation. There's a special telegraphic form used to tell legal researchers how to find particular pieces of information. Let's take the Meritor case again as an example of how to understand this. The official citation for Meritor would read 477 U.S. 57, 106, Supreme Court 2399, 91 L.Ed. 2nd 69, parentheses, 1986, close parentheses. Now, what does this all mean? When you give the citation to a case, you put the volume number first. 477 tells you what volume you should be looking at. Court report volumes all have the volume numbers on their spine. U.S. is the name of the set. That is, in this case, United States Supreme Court reports. Now, there are standard abbreviation tables that would give you what the abbreviations mean. The second number, 57, is the page on which the case begins. Now, that's the standard format. Volume number, name of the set, and page number. If there was a second number after the comma, that number would relate to the particular page in the case that you were referring to. That's called a pinpoint cite. Now, we've already seen where to find the case, volume 477 of U.S. Reports, page 57. Why the other 2 cites? Here again we have a parallel citation, just like we saw at the beginning of the Meritor case. Two other places where the same case is published by commercial publishers. You read the citations the same way. Volume 106 of a set called Supreme Court Reporter, in fact, that's the one we were just looking at page 2399. Exactly the same case is found at volume 91 of Lawyer's Edition, second series, page 69. Second series is important. Many court reporters reach a certain number. It used to be 300, although not any longer. And then they'll start numbering all over again, calling it second series or third series, and sometimes even fourth series. That series statement is crucial. Volume 91 of Lawyer's Edition first series is, of course, totally different than Volume 91 Lawyer's Edition second. So watch for it. That's important. These other two sets will print exactly the same case. Different headnotes, of course, different syllabus, different editorial enhancements, but it would be the same opinion by Justice Rehnquist in the Meritor case. The final listing in the parenthesis, 1986, is the date of the decision. Sometimes you'll find more information in that set of parentheses. Sometimes there'll be indications as to what court decided the decision or where the decision came from. The point is this standard format, volume of the reporter, name of the set, and page can guide you to any case in the library. You should be equipped now to walk into any law library stacks and understand what these case reporter volumes are all about. You understand how they're organized, you know the standard information that's inside most of them, and you understand how to find the citation. You even should have a good grasp of the kind of issues of law and their resolution that are contained inside them. Now, we could spend a great deal of time talking about individual sets of reporters. I could give you the lists of every regional reporter in the states inside it. I could give you the materials that contain all of the federal cases. But that kind of information doesn't make any sense in a lecture format. We've put it in the handbook that comes with the tapes. Look at it at your leisure, if you like to think of legal research as leisure. What I want to do now is take this information and recapitulate it. We've seen all of the primary source materials now. We've seen constitutions. We've seen legislation. We've seen administrative rules and regulation. And we've seen case law. There are a few remaining tools that help us tie it all together. Think back to the research roadmap for a second. What was step one? We thought about our destination. We thought about what our question and answer was. What was step two? We tried to get a lay of the land. We worked our way through secondary sources. What was step three? We focused our plan. We really did our roadmap out. That took us into step four, and that's where we found the primary sources. Because if you're doing that kind of serious research, you're going to run into statutes, constitutional provisions, administrative rules and regulations, and case law. So now we've reached step 5 of the research roadmap, updating and evaluating. You know, we've already seen a lot of ways to update. We've seen pocket parts. We've seen pamphlet supplements. We've even seen loose leaf services where you throw out old pages and put in new ones. But we've got a few more things to see. We've got to take a look at Shepard's, a way of updating your primary source materials. And I want to give you an introduction to Digest as well as the ALR system of annotations. So we've got a little bit to travel. Let's go back to a comfortable setting away from the stacks where we can finish our journey together. We have just seen a truckload of information in the library. There are a few more tools that we have to talk about now, though, and these are tools that are built on the primary sources themselves, that organize these primary sources for you and might be of help to you in your research. The first of these is built on cases, as so many of our research and finding tools are, and they're called digests. Now, what are digests? Digests are subject arrangements of cases, but not of the whole text of the case. They don't reprint the entire case in subject order. Instead, they use what we saw, the headnotes. They take the headnotes that have already been prepared of the decisions and arrange them in a subject order. Now, the major publisher of these digests is our old friend, take a guess, the West Publishing Company of St. Paul, Minnesota. In the 1880s, at the same time John B. West was thinking up the National Reporter System, he started the American Digest System. Since the West Company publishes in its National Reporter System every case from the state and federal jurisdiction that appears in print, they have the headnotes from every case. And they take those headnotes and put them into their pre-existing subject order. Now, How can you conceive of these digests? Let me explain it this way. What they tried to do at West was create a system that provided for every possible legal situation. It's like the old Johnny Carson and Ed McMahon bit. Every possible legal situation would be on this list. They divided all of the legal world into 400 plus separate topics. Now, the way I like to visualize these is as a wall of mailboxes, each mailbox being devoted to a particular topic. And then they took each topic and subdivided it into as many subdivisions as were necessary. Large topics like criminal law would have hundreds of subdivisions under it. And they named each of these subdivisions a key number so that you would have a topic and key number. And when they were finished with this list, they had a wall of mailboxes that provided a location for every possible legal issue that could ever come up. One of my colleagues, Dan Dabney, calls this the world of thinkable thoughts. What they said was, we will have a pre-existing location for every possible legal issue, so that whenever we write a head note in any West case, at the time we write that head note, we can say, where does it belong in the list of topics and key numbers? Think back to the head notes we saw in the decision in the Meritor Savings Bank case. Each of the numbered head notes had a topic and key number designation. You will find those in every West publication. Well, what does that mean? That means that West has a huge database of the head notes from every American case, from every jurisdiction, arranged by topic and key number. And they can take that information and publish it however they want. They have a huge blunderbuss publication called the Decennial Digest. What is the Decennial Digest? The Decennial Digest is a publication of all of the head notes from all of the decisions in every jurisdiction. It's so huge, they can only do it in 10-year increments. And in fact, they're now down to doing it in 5-year increments. This entire volume is only one in a set of some 40 volumes that contain nothing but head notes from decisions, all in the topic and key number order common throughout the West system. So that if we found that head note 1 in the Meritor case had a topic and key number that was right on our research point, we could go to the Decennial Digest, and for the period of time covered, we could find cases from every jurisdiction in the United States that were about the same particular subject. And West subdivides these. If you were only interested in federal cases, West has taken care of you. And there is a digest of federal cases, being all of the head notes of federal decisions arranged for you. There's one for the Supreme Court. They've done it for the states as well. If you wanted to see Texas cases or California cases, there's a set of the head notes from California, from Texas, from every state, but always using the same set of topics and key numbers, so that once you've found a useful topic and key number, you can take it to any jurisdiction, to any time period, and you will find your information. Now, for years, legal researchers have talked about, how do I get my topic and key number? Because once you have the relevant topic and key number, you have access to an enormous pre-existing research system. Thousands and millions, probably, of hours of research time at West over the last 100 years compiling this huge system for you. Well, I'm not going to bother telling you at all how to find your topic and key number using the digest. I don't think you should start with the digest. All you need is one good case. Because if you find any case through a how-to manual, through a horn book, through a nutshell, through an encyclopedia, through an annotated code, one good case, all you have to do is go read that case in a West Reporter system, find the head note that describes the issue of law that speaks to your research, and then you can take that topic and key number and use the digests if you wish. So that there are ways to find your topic and key number. There are tables. There are other methods. I'm not even going to discuss those. Now, in the handbook that accompanies your tape, we're going to refer you to the classic works on legal research. Everybody and their Uncle Fudd, and that includes me, have written books on how to do legal research. And if you want to use the topic and keyword method, and if you want to start in the digest, you can go read 50 pages on how to do that. What I say is, use this system and exploit it, but don't start there. Find a good case that's on your point through some other tool, and if you want to read similar cases, go read your case in the West system and skip all of the intermediate steps. Now, there's one other thing about the digest I do want to mention that's very helpful to many lay people who are researching, and that is the table of cases volumes. Every one of these digests will have a table of cases volume, and that is they'll create an alphabetical list of all of the cases from which head notes are taken, so that if you only have the name of a California decision, Bering versus Sajak, you want to find Bering versus Sajak, if you go to the table of cases of the California Digest, which might be in 2 series. It might cover 2 periods of time, in some states 2 or even 3. But you can find for all of those years, was any case ever called Bering versus Sajak, and you'll get the complete set of parallel citations, okay? So that you can find a case by name. If you only know the date, if you only know it's Bering versus Gabor, a case from the 1950s, I don't know if it's state, I don't know if it's federal, you can go to the huge blunderbuss, go to these big decennial digests in 10-year clumps, because they have 10-year indexes of every case from every jurisdiction. You can see why I call them the blunderbusses of the law. Just huge masses of information for you. So that's the traditional digest method. Now, there are other digests. Lawyers Co-op, Bancroft Whitney publishes some state digests. Lawyers Co-op, Bancroft Whitney has its own Supreme Court digest. It's set up the same way. Of course, they can't use the topic and key numbers. West has a lock on those. But they come up with their own topic and subtopic arrangement. And if you want to use those systems in your jurisdiction, you'll find they always tie into some court reporter in your jurisdiction. It's going to be the same link between the head note and the eventual arrangement. You can use my same backwards method to find one good case in your jurisdiction and then take it to the digest. They'll always have the useful table of cases volume, no matter who does the digest. So there we have digests, a traditional bugaboo, something that has driven legal researchers nuts for years. It's not going to bother you. You're only going to use it when you need it. But there's another hairy bear waiting in the cave of legal research. And you know, it's almost unfair that we've saved it till the end. Shepard's. What is Shepard's, and why is it driving so many people crazy? Shepard's is another creation of the 19th century. You know, sometimes I think that a spaceship must have passed over Earth and bathed the Midwest in waves, because all of these great legal research products developed at about the same time. Frank Shepard was a book salesman who had an idea. Now, what was his idea? His idea was it would be useful to legal researchers to have what I call total blowback. You find a case, the Meritor Savings Bank case, that really is useful in your research. Well, you might have 2 questions about that case. The first is, has my case been overruled? Remember our 3-part court diagram. As your case works its way up, perhaps it's from the appellate level, it might get overturned at the higher level. That's obviously crucial for you to know. But there's also a kind of overruling I call horizontal overruling. That's overruling on the timeline. The same court, or a higher court, years later might change its mind. We read about this in the paper all the time. The current debate over the Roe versus Wade decision. Will the U.S. Supreme Court overturn itself? So you need to find out for your case, has the court that made your decision at some subsequent point in time overturned itself? So that verification function, is my case still valid or has the court changed its mind, is the first thing you might want to know. The second thing you might want to know is, for research purposes, if you find a case like Meritor that's right on point for you, you might say, I'd like to see other cases that talk about this case, other cases that mention my case, that refer to my case. And that's what Frank Shepard came up with. A system that would allow you to take your citation in a case like Meritor Savings and check it in a table that would tell you every subsequent mention of your case. Now, included in there, of course, would be any cases that overrule it, any cases that criticize it, but also any cases which even discuss it, which even mention it. In fact, if you had a case that said, you know, there's a lot of cases that apply here, but I'll tell you one that certainly doesn't, Meritor Savings has no relationship here, you'll see that one as well. Because Frank Shepard came up with a totally automatic system. Now, not using machines, he thought this up 100 years ago. He used people. But he created such a reliable system that we've paid him the ultimate compliment that our culture can bestow. We've made him a verb. Lawyers say, did you Shepardize your case? Hey, I Shepherdized today. I often wish that one of my grandparents had thought of it. Wouldn't it be great? Did you Beringize this? The Barings are off the shelf. That's what happened to Frank Shepard. Now let's take the Meritor Savings Bank case and walk it through Shepard's and see what the mechanical operation is. Shepard's publishes itself in bound maroon volumes. These are permanent volumes that contain information about citations. Because Meritor is a U.S. Supreme Court case, we would use Shepard's United States citations. We would go to the bound volume to find the permanent listing of the case. If we look inside the volume, you'll see that you look for the citation the same way we saw citations set up, by the volume number and then by the page number. We're looking here for volume 477 U.S., and we look for page 57. And there will begin the listing of all of the subsequent mentions of our case. Now notice a few things here. The first is that Shepard's is trying to help you. They're giving you the comprehensive blowback of all citing cases, but they will tell you a few things about those cases. In the left-hand margin, next to the citations, you will see some small letters, some S's, some F's, some D's. What do those mean? Those mean that the editors at Shepard's have decided that the case that cites to your case, that mentions your case, does something specific to it. It somehow either follows it or criticizes it. It does some specific and explicit operation. Now, Shepard's is very conservative about giving these little letter notations. What do the letters mean? Look in the front of any Shepard's and it will be explained to you. I actually tell my law students not to try to memorize these things. They're sort of counterintuitive abbreviations. But if you follow one of my golden rules of research and read the directions and look in the front of the Shepard's book, you'll not only see a pretty good explanation of how to use Shepard's, but an explanation of every abbreviation that's used in the set. And that applies to the listing as well. Some of these listed citations are very difficult to read. Shepard's uses abbreviations that are used no place else. But in the front of every volume, there'll be a table that explains what every abbreviation means. You don't have to leave the volume to lose your confusion. Just follow the golden rule and read the directions. Now, we've looked. We can check on the validity. We see our case has not been overruled or reversed because we've looked up the letters that stand for those functions. We see every subsequently citing case. Well, what about more recent cases? We would have to go to the shelf and use another part of the Shepard's set, a paper-bound update volume. In this case, we have a gold volume that brings us up to date. Now, Shepard's is a cumulative set. That means that the information printed in the bound volume is not repeated in the updates. So that you always have to go back in time to when your case was first decided and trace it through. If you had a 1981 case and a 1986 bound volume, you'd have to check in there. The most common mistake is people only look in the most recent Shepard's and think they've done everything. If you want to find everything that's ever happened to your case, you have to go back in time to the point when your case was decided. Now, in this U.S. Supreme Court example, it's quite simple. We only have to go to this one gold volume. Every Shepard's will have this line, and this line will tell you what your library should contain. So that if you go to the most recent one, Shepard's is trying to help you. It's trying to say if you want a complete citation history on your case, use everything listed. In our case, it's only this gold volume and the bound red volume. Now, I brought examples from other Shepard's because you will sometimes see a red paper copy like this. This is an intermediate volume, usually compiling a month or two. And in some cases, you'll even get these paper pamphlets, which bring you on a weekly or monthly basis up to date. But whether it's paper, red cover, gold cover, or bound volume, it all conveys the same information. Let's open up this supplement of Shepard's and see what it says about the Meritor case. And you can see more citations to Meritor. Now, you might have noticed some of the small numbers on the right-hand side of the citation. What does that mean? This is another way in which Shepard's is trying to help you. Shepard's is saying that when the case mentions your case, it's only mentioning the material discussed in one of the headnotes of your decision. Now that means that if you're interested in headnote 2 and your decision, and you see that one of the cases that mentions your decision only discusses headnote 5, you don't have to worry about it. On the other hand, if you see that one of the cases that mentions your decision does talk about headnote 2, you want to see it right away. Now my rule with Shepard's is, anytime they assign one of the small letters meaning something has happened, you want to look at that case. Anytime your headnote, if you have focused on a headnote, appears, you want to look at that case. Just be sure that you've looked at all of the relevant parts of Shepard's. Now in the handbook that accompanies the tape, I give you a few more examples of how to Shepardize. But the real trick is reading the directions in the front, being sure that you have your citation correct, and updating it all of the way. Shepard's is not that hard to use, but it is sort of the macho tool in legal research. I think that people view this as the litmus test. And if you can Shepardize, if you can go into the library and say, I'm comfortable Shepardizing, then you've shown that you've really mastered legal research. It's the muscle car tool. Now, Shepard's is online. And if you had access to a Lexis or Westlaw terminal, you can Shepardize in an online environment. And it is much easier. You don't have to worry about the updates. It is all accumulated for you. You don't have to worry about the abbreviations. They're all spelled out. But once again, if you don't belong to a law firm, and if you aren't a law student, it's very difficult to get access to these tools. I tell my law students, you might not work in an environment like that. Learn how to use the paper Shepard's. Are there any other traditional tools that I want to mention? Yes, there are. The ALRs. Now, what are ALRs? This is a set produced by the Lawyers Co-op Bancroft Whitney Company. ALR is organized around case finding. It's an old case reporter set that has evolved over the years. What they do is select 100 or 200 important cases every year and assign one of their research editors the task of writing what they call an annotation. Not like the annotation in annotated codes, but instead an annotation which gathers together every case that talks about your case. Now, ALR can be an incredibly useful tool if you can find an ALR annotation that's on your point. And I'm a big fan of ALR. Why? Because I like underdogs. People seem to be very down on ALR these days. I also like it because it's everywhere. It's in every major collection. In almost every law firm collection, you'll find a set of ALRs. It looks confusing because it's gone through a variety of publication formats. There is ALR, there's ALR second, there's ALR third, there's ALR fourth, and there's ALR Fed. The only difference between all of these is how you keep them up to date. And because most annotations you're going to read will be in either ALR third, fourth, or Fed, you don't have to worry. In those volumes, you just look at a pocket part. It's our simplest form of updating. ALR has a general index that sits at the end of the set, a large red set of indexes which I think use a pretty good natural language approach. So if you were looking for sexual harassment, you could go to that general index, you could look under sexual harassment, and find whether any ALR annotations had been written on your point. And in fact, a large number have. You could see if any spoke to the particular nuance of the issue that interested you, and then you could go look at the annotation itself. And if you find an ALR annotation on point, someone will have done an enormous amount of work for you. This takes us back almost to step 2, because it would help give you the lay of the land in that it would discuss important cases, but it's also down there in step 4 because it would be focusing you in on your research. You also can update ALR. The index volumes have a history table, which will tell you if your annotation is still valid, and that's kept up to date by a pocket part as well. So it's updating on top of updating. I like ALR because it's easy to use. There are a variety of digests and ways to get into it. My advice is forget all of those. Those are just confusing. Use the general index at the end. It takes you 30 seconds. You look it up. You don't find it. What have you lost? Half a minute of your life. If you find what you need, what might you save? 3 hours of torture and agony in the stacks. So think of ALR as a useful tool. Now, where do we end up? Well, we end up at the end of a very long journey. I remember some of those family vacations with my folks, and they were long journeys. How many times can you sing 900 bottles of beer on the wall? But we've gotten you to the end of a research journey. We gave you a roadmap. The first, what is your question? Our first step, what is it you need to know? When you've identified that, you get into the library and you start researching. Once you're researching, what do you need? The lay of the land. Be sure you got the map pointed the right direction. We talked about secondary sources that can help you do that, and they may be secondary sources where the marble drops out for you. Maybe the how to use these tools books is enough. Maybe the Horn book, the Nutshell, the how-to will do it for you. Perhaps that will solve your need. But if not, you will now understand the context in which you're operating, and you can move to step 3 on your research roadmap. That is focusing your search and planning the route, using some of the specific indexing and organizing tools that we've talked about, deciding what you have to use, and drifting into the primary sources. Seeing, do I have to read some cases? Do I have to use some statutes? Do I need some administrative rules and regulations? And what I hope you now see is how all of these things interrelate, so that when you move down to step 4, you see how they all fit together, how they cross-reference, how you can get to them quickly. I spent a lot of time slogging you through cases, trying to help you see what cases were. We gave you a pattern for statutes. We talked about rules and regulations, so you can understand how to juggle and mix and match these sources. I think it's crucial at step 3 and 4 that you operate with confidence. Then we looked at step 5, updating. We've talked about Shepard's, the ultimate case updater. And I should point out that there are Shepard's for every statutory compilation as well. There are Shepard's for the CFR and for administrative decisions at the federal level. But usually you are not going to need those. The Shepardizing function that those perform are probably better served in some of the secondary sources. Certainly for legislation, you're better off in an annotated code. But you can update with Shepard's. We looked at pocket part updatings. We looked at other forms of updating. Be sure you have the most recent information you can, and then evaluate. Have I gotten to where I need to be? Is this the motel where we have the reservation? Or am I off in some used car lot someplace? Remember, the research architecture changes. They tear the buildings down. They change the addresses. They move them around. Even as we're making this tape, somewhere a court is deciding a case that has something to do with your research. It's impossible to ever be sure you're totally up to date, so be sure and do the best you can with the tools presented. One part of every research tool will involve updating. And finally, you get to step 6, knowing when to stop, knowing that I've seen everything I can see, not being intimidated by the walls and shelves of reporters and statutes and rules and regulations, knowing that you've understood the systems, knowing that you've exploited the WEST system, that you've exploited the Total Client Service Library, that you've used the indexes as well as they can be used. Where does that leave us? Well, I want to leave you with what I call Bob's 4 golden rules of research, things that we've met along our journey and that I hope that you can take with you. My first rule of research, my first golden rule, is find someone who's done the work before you. Don't reinvent the wheel. Trust me, it's all been done. In a law review article, in a loose leaf service, in an encyclopedia, in an annotated code, someone has dug and mined and rearranged and put it all in a fashion for you. You remember where you are in the research spectrum. And remember, if someone is telling you something, what they're doing is serving as your lawyer. Don't trust them any more than you'd trust your lawyer. But use them when they can help. My second golden rule of research, find a human being. And here it's often a librarian, a reference librarian who can give you the lay of the land, who can't do the research for you. He or she won't have time for that. But who can tell you what books are useful, what indexes to use. No law library is the same. I wish I could give you a tour of your law library. I wish I could show you how your law library is set up. I can't do that. But the reference librarian can. He or she can indicate the best method for you to take. Librarians are there to help. If you treat them as professionals, if you have your question well in mind, if you have a research plan, they will generally enjoy helping you to get to your destination. My third rule of research, read the directions. In almost every set of books that we've talked about, there are how-to-use sections. There are manuals for users. You never need to be lost in using these tools if you take the time to read the directions. Now, I know that's very difficult. We as human beings don't like to read directions. But if you can make yourself do it, it will save you an enormous amount of time. One of the things that reference librarians like the least is someone who comes up and says, "How do I use this set?" And they haven't even read the directions themselves. My fourth golden rule of research is never give up. There are many roads to every answer in legal research, many ways to get there. There are alternative tools at many junctures. If one annotated code doesn't work, perhaps there's another annotated code. If you can't find cases through an annotated code, perhaps you can find them through Shepard's. Maybe you can find an ALR annotation. Maybe there's a Horn book that discusses this. Maybe there's a nutshell. The biggest problem in research is people get locked into doing things one way. You learn to perform a function from A to B, and you never vary. That's why I stress the functional nature of these materials. If you get stuck, think for a moment. How do case reporters work? How do they fit together? How do statutes work? How do they interrelate? What tool am I using and why is it put together this way? Then when you can't go any further, go back and ask a human. Get some help. But you never have to be frustrated because a book's not on the shelf. You never have to be stopped because you can't find the right index entry. Trust me, there's always more than one way to get to the end. So where does that leave us? Back here, in the law library. But the library is not an intimidating place now, and it shouldn't scare you. You should understand how the materials on the shelves work, how it all fits together. Legal research doesn't have to be a crazy enterprise. It's nothing more than good common sense, understanding a few patterns, and seeing how the research spectrum works. That's why we gave you a roadmap. Figure out your destination, and you can usually find it in the law library. Don't be afraid. I'll see you there.